Hello, this is Grant Hughes of Grant Hughes Investigates on YouTube. Please hit that like button, share, and subscribe. Some new documents came out yesterday in the Idaho 4 murder case regarding Brian Koberger, who is alleged to have killed Madison Mogen, Kaylee Gonzalez, Ethan Chapin, and Xana Kernodle. I believe Brian Koberger is the killer 100%. So in the document, we heard about a whole bunch of different things, and new information popped up yet again. This one is regarding the 911 call. There's nothing new in here, but there's a ruling made. It says 911 call mostly allowed. Bethany Funk and others on the line were clearly distressed. Their statements like something happened in our house are real-time reactions and are coming in. The court says things like crying, breathing, and panic aren't hearsay and help show how intense the moment was. Blocked or redacted. 3 specific parts are not going to be allowed. A girl said a roommate was passed out and drunk, but she didn't see that herself. She also said someone saw a man in the house last night, hearsay, and too old. So meaning it was 8 hours later and somebody could have thought about what they were going to say. And she was just repeating what Dylan had told her earlier. Dylan Mortensen tried to start explaining what happened at 4 a.m. Again, too delayed and shows reflective thought, not raw reaction. I'm not really sure why that can't be allowed. She didn't really discuss anything. She just started to say, but maybe the 4 a.m. portion was something that they didn't want in there that way. They're going to use other information. But she said the same kind of things to the grand jury and in different interviews, etc. So I'm not really sure why that can't be in there. 911 transcript. The judge will let the jury read the transcript while they listen to the audio, but only as a visual aid. It won't count as actual evidence. They will get instructions not to treat it like gospel if the audio sounds different. So the court's decision is text messages mostly allowed, especially in that early AM panic window. The 911 call allowed except for 3 statements that lacked personal knowledge or were too delayed. And the transcript is allowed with the right instructions, but not as official evidence. This next section was regarding autism. And I'm just going to show you what the results were of the judge's findings. The defendant alternately argues he should be exempt from the death penalty because the intense media scrutiny on his ASD undermines his ability to present a meaningful defense and renders it impossible for him to receive a fair, individualized sentencing determination. He points out that news sources have focused on his social deficits, including his past interactions with females, his deadpan look, and don't forget, you have nice birthing hips, robot-like walk, cold iciness, rigid posture, and lack of facial affect. He argues the media is demonizing him for his disability, while at the same time emphasizing the brutality of the crime. This, he warns, will overpower any mitigating arguments based on ASD and poses a risk that he will be sentenced based on his disability. As the state points out, however, there is no precedent for striking the death penalty due to media coverage. Further, any concerns that arise from such media coverage can be mitigated through voir dire and from expert testimony and evidence during the penalty phase of the trial. The court ordered, based on the foregoing, defendant's motion to strike the death penalty regarding autism spectrum disorder is denied. All right, those last 2 items that we just discussed were in 2 different documents. And then there's a third document that lists, I think, 7 or 8 different rulings. All right, now this one is on, and they're all based on witnesses that the state is going to be calling. And this is Jenny Ayers. Defense challenges misapprehend the type of expert Miss Ayers is. This is the ruling. Much like law enforcement, Miss Ayers is a hybrid fact expert witness as opposed to a traditional expert. She will be educating the jury on crime scene investigation procedures to provide foundation for her testimony regarding the work she and her team performed in this case as outlined in lab reports 25 and 11 and the accompanying field notes. This testimony is factual in nature, despite that fact that it requires special knowledge, skill, experience, and training. Consequently, the absence of opinions in her disclosure does not limit her ability to testify to these matters. In addition, Ms. Ayers' rebuttal disclosure is replete with explanations about why and how the crime scene investigation was carried out at 1122 King Road. Her testimony will be allowed as disclosed. All right, this is one of the really interesting ones. FBI Special Agent Bounce was primarily involved in the analysis of cell phone records in the investigation. He is disclosed to testify in the state case in chief about the analysis of AT&T cell phone records for defendant Madison Mogen and Xana Kernodle. Well, isn't that interesting? Why just those 2? Do they believe that Madison Mogen and Xana Kernodle were being stalked, and are they going to compare their movements with different dates that maybe Brian Koberger was in Moscow, Idaho, to see if they're in the same location at the same time? And it continues, as well as his own drive testing measurements determine the use and general location of their cell phones between June 2022 and November 2022. Accompanying his initial disclosure is his 30-page CAS report, which discusses and maps the data he reviewed and the methodology employed. Initial disclosure, S-2A, his supplemental disclosure goes through each page of the CAS report to discuss its significance. He will also discuss topics pertaining to how cellular technology works, particularly how cell phone towers operate, and how cell phones connect to towers, how cell phone usage data is reflected in call detail records, and how those records provided by AT&T for the target cell phones in the case were used to create cell site maps showing their general location before and after the homicide and their direction of travel. In challenging Agent Balance's case in chief disclosure, defendant provides the affidavit of his cell phone data expert, Cy Ray. Mr. Ray complains that he is unable to identify Agent Balance's methodology, which was described in the CAS report. Ray states that the CAS report omits data and or fails to mention how certain AT&T data was utilized in his analysis, namely handoff data and drive test mapping, and why some data was ignored. He asserts this omitted data and methodology is exculpatory, and without it, he cannot fairly analyze Agent Balance's work. The conclusion, however, by the judges, however, the fact remains that defendant has all the facts and data that Agent Balance relied upon to form his opinion, which are expressed within his CAS report. Initial disclosure: the data supporting S.A. Balance's opinions is located in the files of the cell phone records provided by AT&T and the drive test files which were provided to defense through discovery. And then supplemental disclosure, page 2, identifying disclosed information relied upon by Agent Balance by description, AV number, and date disclosed. While his methodology might not be set forth with as much specificity as Mr. Ray would like, rule number 16 does not require that detailed methodology be provided. It requires merely opinions, facts, and data for those opinions and the witness's qualifications. ICR 16b7. To the extent defendant believes Agent Balance omitted important data or is relying on insufficient data for his opinions, this is fodder for cross-examination, not exclusion. Moreover, if any opinion is not reasonably set forth within the disclosure, it will not be allowed. All right, this next section is regarding Heather and Jared Barnhart. Who are they? Well, Heather and Jared Barnhart are digital specialists with Celebrite, retained by law enforcement. Their task is to analyze Brian Kohberger's cell phone and PC to determine user behavior and actions. They are disclosed to opine that gaps in data on Kohberger's devices, cell phone and PC, were abnormal. Their joint report, which was attached to the disclosure, details their analysis and findings. Their CVs were also provided. Defense challenge. The defense argued the disclosure suggested the Barnharts would testify to habit evidence, but that this was not explained or supported by any specific opinions. The court found this argument confusing. The disclosures and report do not indicate the Barnharts will testify about habit evidence. Rather, the Barnharts will testify to their findings about Kohberger's activities on his devices before and after homicides and explain why gaps in the data over that time period are abnormal. What their report shows. The Barnhart opinions are fully set out in their joint report. Example findings: gaps in event logs and system resource usage monitoring on Kohberger's PC from November 11th to the 16th of 2022, which is abnormal given that school was in session. Gaps in Chrome browser history during periods when downloads occurred, suggesting private browsing or history clearing. I mean, that is interesting, right? He should have been using his computer for schoolwork, but between the 11th, the homicides happened on the 13th, so between the 11th and the 16th, things have been removed. So you wonder what type of planning information he might have had on there, and things he was looking up after the homicides to check on activities, etc. Gaps in Chrome browser history during periods when downloads occurred, suggesting private browsing or history clearing. The gaps may be consistent with cleaning up or using anti-forensic methods to clear evidence. Their rebuttal disclosures only state that they intend to rebut specific defense expert testimony, but need more information before giving rebuttal opinions. These rebuttal disclosures were not being challenged. The court's conclusion: the Barnhart's disclosures and report meet the requirements of the discovery rules as they set out their opinions and the facts supporting them. There is no basis to exclude or limit their testimony. Yeah, so isn't that interesting, you guys? You know, it looks like Kohberger was deleting information on his laptop right during the crucial time frame. I mean, whole chunks of information. I mean, it looks like gaps in event logs and system resource usage monitoring Kohberger's PC. Gaps in Chrome browser history is missing. Now, the pro-burgers out there will just say, well, he wasn't using his PC on those days. Wow, man, is Kohberger unlucky. All right, this next section is Michael Douglas. Who is he? Well, Michael Douglas is a forensic accountant for the FBI. He was disclosed by the state as a witness to testify about financial transaction data. What will he testify to? Well, Douglas is expected to discuss financial transactions for the defendant, Brian Kohberger, the 4 victims, and the 2 other surviving roommates. So why are they doing that? Why are they comparing his financial transactions to the 4 roommates? Do you think it's possible that they're trying to show that Brian Kohberger was stalking them? And I think that's why they're trying to check the cell phone movement, as we learned previously with Madison Mogen and Xana Kernodle, and they're looking up their purchase history as well. I mean, this is really starting to look like they're trying to show that Brian Kohberger was stalking the victims. Douglas is expected to discuss financial transactions for the defendant, Brian Kohberger, the 4 victims, and the 2 other surviving roommates. His initial disclosure identifies by category and date range the financial transaction data he intends to address, includes his report listing specific transactions found in the financial records of these individuals. His supplemental disclosure further specifies the financial data associated with Kohberger that Douglas will discuss, identifies video evidence showing Kohberger's ATM withdrawals. Defense challenge. The defense contends Douglas should not be allowed to offer any opinions because none are expressed in the disclosures. Specifically, the defense points to the supplemental disclosure, which states Douglas will testify to an analysis of Kohberger's spending habits and argues that no such spending habit opinion is actually disclosed. Court analysis. The court clarifies that Douglas is primarily a fact witness. He is only disclosed as an expert in case the court determines that his testimony relies on specialized knowledge under evidence rules. Although the supplemental disclosure mentions spending habits, Douglas's testimony will be limited to factual observations regarding changes in Kohberger's spending, not speculation as to the reasons behind them. Kohberger only made ATM withdrawals on and after the date of the homicide and stopped using his debit card after November 10th, 2022. I think this right here, this Kohberger only made ATM withdrawals on and after. This is supposed to be before. So it's Kohberger only made ATM withdrawals before and after the date of the homicides and stopped using his debit card after November 10th, 2022. Well, November 10th is before the homicide. Therefore, that should have been before. That word on should be the word before. So we continue on. Even though he regularly used the debit card before then, Douglas will testify to these factual changes, not to any opinions about why the changes occurred. There is no indication that Douglas will offer opinions about the motivations for Kohberger's spending changes. He will simply testify about the occurrence of the changes. Therefore, there is no basis to exclude or limit Douglas's testimony due to disclosure concerns. Additional notes down here, it says the court briefly mentions a potential concern about the relevance of this testimony, but points out that the defense has not challenged it on those grounds yet. And here it is. Without more, the court has concerns about the relevance of this testimony, but defendant has not challenged it on this basis yet. It says it right in the footnotes. Well, I mean, isn't that giving the defense like a hint? Hey, defense, I'm not really sure I'm buying this. But it also gives the prosecution a chance to shore up their arguments as well. But it seemed more defense bias in that footnote right there. Let me know what you think in the comments. All right, the next section is Shane Cox. Who is he? Well, Shane Cox is a litigation and regulatory manager for Amazon.com. What will he be testifying to? His initial disclosure states Cox will testify about the content of documents Amazon provided to law enforcement relating to an Amazon account linked to the defendant, Brian Kohberger. And we know now that Brian Kohberger ordered from Amazon in March a K-bar knife and knife sheath and had it shipped to himself at his parents' residence. I think he was still living there at the time. The document include order history from January 5th, 2022 to December 13th, 2022, click history and sign-in history for certain dates within that time frame. These documents are referenced by their Bates number in the disclosure. His supplemental disclosure specifies the exact facts Cox will discuss from the documents. Defendant challenge. The defense argues Cox should not be allowed to offer any opinions because none are actually disclosed. This mirrors the defense's challenge to Michael Douglas. Again, not the Michael Douglas. Court's analysis. The court notes that Cox is being offered as a fact witness. He is not providing expert opinions. He will simply explain what the documents show based on his disclosures. The court states there is no basis to exclude his testimony for lack of opinion disclosure. Additional defense argument. The defense further argues that according to their expert, David Howell, much more information is needed to attribute specific activity to a specific person or to render an opinion about user behavior with forensic certainty. They assert Cox should therefore not be able to offer any opinion on user behavior. The court responds by referencing an earlier ruling, order memorializing oral rulings on motions in limine, April 18, 2025, where this argument was addressed and rejected. The court declines to reiterate that discussion here. Court's conclusion, Cox will be allowed to testify as to what the Amazon document shows as outlined in the disclosures. There is no basis for exclusion or limitation of his testimony based on the disclosure concerns or on the defense forensic certainty argument. Section F, Darren Gilbertson. Who is he? Detective Darren Gilbertson is a lead investigator for the Idaho State Police in this case. Gilbertson was disclosed in rebuttal by the state. The disclosure says he and other investigators conducted time runs at 1122 King Road, the crime scene, to estimate the time needed to commit the homicides. A report of these time runs was attached to the disclosure. The purpose was to determine if one person could have carried out the homicides within the alleged time frame. Now, I've made videos that shows 9 minutes and 7 minutes, and even the 7 minutes seem too long, and I've stated on my show many times that it could have been less than 5 minutes because there's so much waiting around. I created time during each of the attacks where you're just sitting there for way too long. And it says, Gilbertson's opinion, depending on the suspect's pace and route, the crime could have been committed in approximately 2 to 4 minutes. Absolutely agree. 2 is really quick, but 4 is still a little bit slow. I'm going to show you right now in just a moment here, after we get through this page, a version of it. It'll show you how long that really is and how easily somebody could do that, especially when you have individuals that have been drinking. The defense disclosed expert opinions from Brent Turvey, who suggested more than one assailant was necessary, partly because of the crime scene cleanup and the use of multiple weapons. Additional opinions through another expert that Bryan Kohberger had developed coordination deficit, making it not possible for him to have acted with the required speed and coordination. The state rebuttal with Gilbertson is directly in response to these defense opinions and theories. Defense challenge. The defense argued Gilbertson's testimony should be excluded for several reasons. 1. Qualifications. The state has not shown Gilbertson is an expert in timed runs, whatever the hell that means. Relevance. Defense claims the experiment's relevance is minimal. Then why do you care? Disclosure. The defense says important data, recording, photos, notes from the experiment was not disclosed. 4. Prejudice and confusion. The defense argues Gilbertson was already familiar with the house. The house was vacant during his experiment, not as it was during the crime. The house has since been torn down, so the defense cannot do its own test. Gilbert's opinion risks confusing or prejudicing the jury. The court analysis. Relevance. The court says whether Gilbertson's testimony is relevant depends on what the defense expert ultimately testifies to at trial. If the defense claims Kohberger was physically incapable, the rebuttal becomes relevant. The court finds Gilbertson's experience as lead detective qualifies him to offer opinions about movements through the crime scene. Disclosure. The experiment was simple. Gilbertson timed himself moving through the house at different speeds and simulated stabbing pauses. And that would be similar to my darkness that I put on my crime scene walkthroughs, where you just imagine what happened in there. The court found there was no photographs or additional data beyond what was described in the report. Prejudice, confusion. The court rejects these concerns. The state said there were no structural changes to the house before the experiment. Familiarity with the house and its vacancy can be explored on cross-examination, not grounds for exclusion. The defense stipulated to the house being torn down after Gilbertson's report was disclosed, so any prejudice is their own doing. No basis for jury confusion was shown. The court's conclusion, Gilbertson's disclosed testimony will not be excluded or limited at this time. If the defense believes any of Gilbertson's trial testimony goes beyond the scope of disclosure, they can object at trial. I mean, so that was really interesting. I'm glad that in the documents we now know that law enforcement believes that the crime could have occurred between 2 and 4 minutes. And now that's interesting because if Kohberger is leaving at around 4:17, that's the sound where the thud was made, so 4:17:30, maybe 4:18, and the homicides took place in 4 minutes, then he got into that house at 4:13-ish. And isn't that amazing? Because that's about the time where Xana Kernodle's phone died. So let's take a look at that animation right now. Okay, so here's going to be a quick walkthrough. Now the clock you want to watch is the one over on the left here. I'm just going to use that as a timer, and I sort of modified a video I made a long time ago regarding the 7 minutes. If any time shows up on the screen, ignore that. Look at the clock over here on the left. This is just a timer of how long it could have taken to commit the homicides. All right? So let's play those right now. Okay, we'll add a second or so at the end. So it goes up the stairs. I have him going into Kaylee's room first. This was just a walkthrough I did a long time ago, or pretty much the order that the crime was committed, but I have him go into Kaylee's room. Now during this darkness, so, forget that time on the screen right there. But the darkness is when the attack's happening. So right now he is attacking Madison Mogen. And I believe in the documents that I didn't have in my the information I just gave out a minute ago was that apparently Xana and Ethan were attacked together, like they're in the same room. So I think we learned that tonight as well. Like one of them wasn't somewhere else. So right now, he's already, easily had enough time to kill both of them in there. They were both intoxicated. I think Madison Mogen appeared on the grub truck camera to be much more inebriated. Now this isn't how it went right here, where Ethan's out in the hall. This is just something I made a long time ago based on the information we have, but it's all changed over time. So apparently, right now he's attacking Ethan and Xana. I would imagine he attacked Ethan first, because you'd want to eliminate the greater threat. And Xana was in there, so that's probably why she has defensive wounds, because she was able to sort of wake up a little bit. She was already, pretty much awake because she had just gotten the DoorDash, but you could imagine they're just both really tired, and they too had been drinking. They were at the Sigma Chi party. So again, I mean, look at all this time that's going by right here. Lots of, he's just stabbing and attacking them right now in this darkness. And you could take some of this time here, maybe give it back up to the Madison Kaylee crime scene. This one might be taking too long here already in terms of amount of time that it's taking. So you can, like I said, just take some of this time and allot it back upstairs to Madison and Kaylee. So there is Xana and Ethan there, and then if you look at the clock, it's 2:52. There's Dylan in the door right there, then out the sliding glass door, and that's 3 minutes. So hopefully, can't you just tell that, just based on that it easily could have been done in 3 to 4 minutes? Now, the defense is claiming that there was some cleanup. Now, we've heard rumors about that, and maybe there is evidence of that. We don't know. So I'm looking forward to hearing about that when the trial happens. So let's continue on with the rest of the video. So section G here is just kind of a procedural one. I'll just put the words up on the screen if you want to pause the video and read it if you feel like it. This is a breakdown of it. I'm just going to scroll up here. And the conclusion is there is no basis to prospectively limit the testimony of the ISP forensic scientist or forensic toxicologist. If issues arrive at trial about undisclosed testimony, the defense can object then. All right, this section here, section H with Gary Dawson, I think is important. Who is he? Dr. Gary Dawson was disclosed by the state as a rebuttal expert. What he is expected to testify about. Dr. Dawson is expected to testify regarding the degree of impairment of the victims, particularly Madison Mogen, at the time of the homicides. His expert report attached to his disclosure states Madison Mogen would have been markedly intoxicated from the effect of alcohol around the time of her death. Because of this, she would not have the ability to mount a meaningful response to a sudden threat to her person. While Dawson limited his review to Madison Mogen, he states the same general principles apply to the other victims. And then this goes in nicely with the 2 to 4 minute time frame where the victims were sort of rendered helpless, and you could even throw in how tired they were. They were probably around the time of sleeping or already sleeping, and really wouldn't have been able to defend themselves. How the defense is challenging this, the defense seeks to strike Dr. Dawson's testimony, arguing it's improper rebuttal. They contend that none of their experts have challenged Mogen's ability to fight back or contested her toxicology levels. The state responds, Dawson's opinions directly rebuts the defense expert Brent Turvey's opinion that more than one assailant was necessary to accomplish the crime in the alleged time frame. It's amazing how the Delphi case has some very similar arguments. The state's position, if Mogen was so intoxicated she could not fight back, then it's plausible that one person could have committed the homicides quickly. It's also incredibly plausible even if they weren't drunk. Court analysis. The court defines rebuttal evidence as evidence which explains, repels, counteracts, or disproves evidence introduced by the adverse party. The court notes that Turvey opined 2 assailants were involved, partly because he believes multiple weapons were used, and by inference, one person could not have used multiple weapons in the time allowed if faced with resistance from 2 victims. If Mogen was too intoxicated to fight back, it would make it plausible that a single suspect could incapacitate her and then attack Kaylee Gonzalez with multiple weapons. Whether Dr. Dawson's opinion is relevant will depend on how the defense expert Turvey testimony unfolds at trial. The court's conclusion is Dr. Dawson's disclosed rebuttal opinion will not be excluded or limited at this time. The court reserves judgment on its ultimate relevance until after the defense expert testifies. And this final section here just kind of goes over some forensic experts, Detective Lawrence Mallory, Special Agent Jeffrey Tanzola, Detective Neil Ulrich, the nature of the disclosure, disclosed as an expert in digital forensics. Mallory may testify to any subject in his reports and to the chain of custody, extraction, electronic data, etc. And so Special Agent Tanzola and Detective Ureg will also discuss what they do. The challenges that the defense have, as usual, the defense wants to limit these witnesses' testimony to what has been disclosed, i.e. the devices, data examined, and processes used. The defense argues that apart from disclosed opinions about no connection between defendant and the data, they should not be allowed to testify further about what the devices and data depict, as the state's disclosures did not specify which portion of the devices or data would be addressed. The court analysis, the state clarified that it does not intend to elicit expert opinions from the witnesses, but rather have them testify about their qualifications and their factual work. The extraction and analysis of the identified devices and data, the state also represents that the defense has received all of the data analysis by these witnesses. Court conclusion, the court finds no basis to exclude or limit the detectives' disclosed testimony. Their testimony will be factual in nature, not traditional expert opinion. The defense has all materials reviewed by these witnesses. There is no need for the detectives to identify or pre-disclose the specific portions of the devices or data they will discuss in testimony. Any objections can be raised at trial if the defense believes the testimony goes beyond the disclosures. All right, well, there you have it, everybody. That was the entire sort of a summarization. If there's any portions that you think I left out, put those in the comments section. Let me know what you think about all this different information. I was particularly interested in the short time frame, and I was kind of wondering if the Xana Kernodle's cell phone disconnecting from TikTok, if that was connected to Kohberger in some way. Now it's starting to seem very plausible that her phone was turned off because of that. Now, when we see at the end, when he leaves the house at 4:17 and he's driving away almost 4 minutes later, man, it makes you wonder then. So if he gets there 4:08 and took 4 minutes to get in, it's 4:12 when he's entering, so that's like 4 or 5 minutes. You're leaving at 4:17. And getting in there at 4:12 is exactly the time where Xana Kernodle's phone quit using, I think it was TikTok. All right, so again, leave comments in the comment section. Let me know what you think. Thank you all for watching. I hope you appreciated sort of a shortened, condensed version here. Again, thanks for watching. And as I always say, until next time, be safe out there.